LLC. Counsel, your appearances for the record.
Thank you very much, Your Honor. Jason Geisler, Assistant Attorney General on behalf of Dana Nessel.
I can't see what that on the screen.
Oh, why is it on the screen? All right, thank you. All right, on behalf of defendant.
Good morning, Your Honor. John Yunchai on behalf of Kalshiaks. Go ahead, Andrew, sorry.
Good morning, Your Honor. Andrew Porter on behalf of Kalshiaks.
Thank you. And what is today's update? We had a good report last week. There were a couple of, I think, hiccups that the people wanted answers to. What's going on today?
So, Your Honor, as far as I know, we haven't had any outreach from the state questions. We've continued to monitor and seen the CBS other restrictions be working and haven't heard otherwise. We've had the force upgrade in place for over a week. The Apple update we expect is rolled out to everybody at this point. So anybody who has an
Wait. Just a minute. The court reporter will tell you where to. It's just harder on Zoom. Just have to talk a little bit slower and enunciate. Where would you like them to pick up?
The Apple update we expect is rolling out to everybody.
So by this point, we expect the Apple update has rolled out to everybody. Apple does not give us a confirmation of that, but anybody who hasn't updated at this point, we expect has functionally left the app since the force update has been in place for a week. We did confer with the state over entering a preliminary injunction. They sent us a draft last Wednesday. We sent them comments on Friday. We're awaiting a turn on that, and I expect as we finalize that, we would have something we'd be able to submit.
We would have something to be able to what?
To submit. On behalf of plaintiff.
Thank you, Your Honor. We did receive the draft PI with the proposed edits from Kalshi. We have discussed those, and we do not have any issues with the proposed edits. So my guess is we'll be able to finalize that order in very short order. One thing that we did want to bring to the court's attention that we learned on Friday was we received some correspondence from Robinhood Derivatives, and they sent us an email advising that they are still able to offer sports-related event contracts in Michigan that were certified and are traded on Kalshi Exchange, and that Kalshi has not directed them or requested that Robinhood cease opening new contracts for its customers who are residents of or located in the state of Michigan.
Can you address that? I'm sorry. So, I'm sorry. Did you have anything else to say? I just wondered if they could address that.
Well, in addition to the information that was provided by Robinhood, we do have investigators who were able to confirm that information this month.
Mr. Porter, are you aware of that?
So this actually relates to an issue I wanted to bring up, Your Honor, which was a little confusion on our part about the way, I guess what I would say about the state's assertions of harm. So the way this works, Kalshi is what's known as a DCM, a designated contract market. There are other DCMs that operate and are currently operating in Michigan, such as Polymarket. And Crypto.com. And there are entities known as FCMs, which sell to their own customers through their own platform contracts. Robinhood, I believe, allows users to buy and sell Kalshi contracts, but it is through Robinhood's platform. It has been curious to us that the state has initiated actions against Kalshi, but none of the other entrants in the marketplace. That's particularly so since several of the others sued to seek preliminary injunctions blocking the state, and the state defeated those preliminary injunction motions, giving it a clear path to move forward against them. With Kalshi cannot, or as far as I know, Kalshi cannot control what Robinhood chooses to offer or not offer. And I would have expected, given the action against Kalshi and the harms alleged by the state, that the state would have brought similar actions against Polymarket and Crypto.com and Robinhood. But that is, though that is a different company. Robinhood also, in addition, operates, I believe, a DCM called Rothera, through which most of its sports contracts are offered. So that is really a Robinhood specific offering that I would expect if the state wanted to stop Robinhood from offering sports event contracts in Michigan, the correct recourse would be for the state to bring an action against Robinhood and seek a preliminary injunction similar to the one it sought against Kalshi.
While I would tend to agree with you, let me ask you a couple of questions. And I don't know if they need to be brought in this case because it's related or a separate one gets open, but let me just ask you this. Is Kalshi selling anything to Robinhood? And if they are, regardless of doing business with them, shouldn't there be part of a contract that says you may not sell to Michigan? I mean, how is this happening? It's your company. So how is this third party having access and reselling? Shouldn't there be something to all of your people that you sell to, that there's a notice that Michigan, New York, whoever has this issue, they cannot sell to, or you won't sell them anything at all?
So we do not sell to Robinhood.
Well, okay, maybe it's the wrong term, but how do they get it from you?
So Robinhood introduces their clients and allows their clients to buy and sell through the Robinhood platform. And some of the contracts sold on Robinhood, I think mostly not sports, are connected through the Kalshi exchange ultimately, but it is a Robinhood interface to Robinhood clients. We don't know who those clients are. We get, I think, an identification number with the trade, but it's not something where we can reach into the Robinhood app and impose the sort of restrictions. We can only control our app and what we're able to offer to our direct clients. That would be, particularly with this Rothera exchange, which is sort of Robinhood's own internal Kalshi, something we're not able to, we don't know how they're routing their customers. And it is really, if you want Robinhood to stop offering, I think the case is properly brought against Robinhood.
So are you going to bring, on behalf of the Attorney General, are you going to bring them into this case, open a new case?
Philippe, do you want to weigh in on that?
Yes, Your Honor. Philippe Hall on behalf of AG. First, a couple of clarifications. Robinhood reached out to us in relation to the TRO that you issued, and in an effort to be in compliance because they are an affiliate of Kalshi. And as you recall, the original TRO said the affiliates, Robinhood, Kalshi and the affiliates had to stop offering contracts. So Robinhood reached out and indicated these are the contracts that we have from Kalshi right now. And that was at the very beginning of the TRO. They have subsequently given us information this past Friday that Kalshi has never told them to stop. So they've kept opening contracts from Kalshi on their platform. We believe that's a violation, a continuing violation of the TRO, because it in essence says that Kalshi never stopped providing these contracts in Michigan despite your order saying they were supposed to. And the information that Robinhood has provided us isn't from Rothera. It's all the contracts are open from Kalshi and only Kalshi.
So is Robinhood the only one that's an affiliate? Because council mentioned there are, 3 or 4 others that are acting the same way. Is is that different than how Robinhood acts?
Unfortunately, he's somewhat misstating it. Polymarket is a DCM also, so they are not affiliated or doing business with Kalshi. They have a separate market, and that's the other entity they're referring to. And Coinbase, we are in active litigation with in the Eastern District, but the preliminary injunction was denied, so we're addressing that. It does not suggest that we will not bring complaints against various other actors that are violating Michigan law. It's just that we brought it against Kalshi first, and then the others went to federal court first. So it's a nuanced situation where it's just a matter of us getting out of federal court and back here.
Well, you know the answer from federal court. I don't know why you wouldn't just bring them all immediately to state court. They're in violation of the law, and Kalshi now is in this test case. Now you have these others, bring them on in. I mean, we know there's a difference between the federal and the state. As to Robinhood, if Robinhood is an affiliate, we can have an evidentiary hearing Monday morning or Monday afternoon. I'm in jury trial, but I can take a warning and do this. We can bring in Robinhood and see who's violating what, and we can, I think, amend the preliminary the preliminary injunction to include or further define what affiliate means, to include but not limited to Robinhood, etc. Perhaps that helps it get everybody served. I don't know which direction you want to go.
If I can clarify, Your Honor. So Robinhood is not a corporate affiliate of Kalshi or in any way part of the Kalshi sort of family of entities. Robin is a counterparty to Kalshi in certain business transactions, but that does not render it an affiliate. They are a competitor that offers through Rothera their own DCM, sports event contracts. They have historically, through the third-party relationship, offered some Kalshi contracts. I don't know the extent of their current Kalshi offerings. It sounds like they made a representation to the state. But again, we have no control over the Robinhood app or what they incorporate into their app or what they are, how they're sort of specifically interacting with their customers. What we do have control over is the Kalshi app and the Kalshi website and interface, which is where we've integrated, all of these things. And I think any action to stop trading on Robinhood would necessarily be brought against Robinhood, not Kalshi.
Your Honor, we're just trying to get clarification as to why they simply couldn't reach out to Robinhood at this point in time and advise them, hey, we're subject to this TRO, and we're asking you not to offer any of our trades on your platform because it gives the appearance that we're violating the TRO. And I would argue that they are still an affiliate. Otherwise, this would simply allow them to do an end around by using some third-party intermediary.
Well, I was just gonna ask that, can you change your contract, and we can also modify the preliminary injunction that says that Kalshi will notify all parties? Because I don't know how many there are, they're gonna crop up because this is big money. That says that trades to third parties, that Kalshi will not, that anyone who does business with Kalshi will not trade with a third party in Michigan.
So I'm happy to
Languages.
Sure, and I would have to confer with my client about exactly how this relationship is structured, and I'm happy to have a discussion with the state about what that communication would be. We understood the order to be Kalshi corporate affiliates because I think that's the language is affiliates as it commonly understood. But obviously, we want to be in compliance with the order, and if there's a message to give to Robinhood, we're happy to do it. But I think what I want to emphasize most of all is the information, as I understand it, from Robinhood is very limited, does not include the location of anybody that's trading. They have their own setup in terms of their customer information, and they have their own obligations as an FCM to verify someone's location. So that's all something that has to be done on the Robinhood end. If the state's view is that the preliminary injunction should have encompassed Robinhood, I think we would disagree that the current language does that, but I think we'd be more than happy to sit down with the state and work on language and communicate a message to Robinhood about what, and again, this is all information that Robinhood would have. We don't see where Robinhood's customers are, about what Robinhood should be doing. And, you know, with the Rothera exchange out there, which I understand every day more and more is where their sports trading is, you know, we think that the action would be against Robinhood properly in the first instance, but we're happy to, you know, have a call later today with the state or at some time convenient to the state to talk about a message they would like us to communicate, again, subject to me speaking with my clients.
And we are definitely open to having a conversation. I would just reiterate, this was Robinhood reaching out to us saying, hey, we are trading these contracts for Kalshi, and therefore we're letting you know this is what's open and how do you want us to proceed in closing them.
Well,
And part of
they
that,
literally, I'm sorry to interrupt, but Robinhood, it's very interesting to me that they're doing it when they question, well, we shouldn't probably be doing it. So let's put them in the preliminary injunction under affiliates to include, but not limited to Robinhood, et cetera, for third parties. And then if they continue, we'll have an evidentiary hearing and I'll hold them to the same standard of the $500,000 a day.
sounds fair, Your Honor.
Thank you, Your Honor.
I'm available all week, and then if you want to have an evidentiary hearing, I'm gonna need some notice because I'm in this trial, but, you know, it could be Monday, morning or afternoon, or Tuesday morning or afternoon, et cetera, next week. So everybody has notice to prepare, or we could find a day for an evidentiary hearing in the next couple of weeks. But otherwise, I'll see you, Monday morning at 10, if not before, and I'll look for that order.
Yes, Your Honor. Thank you.
Thank you, Your
Thank you
Honor.
very much, Your Honor.
All right, thank you, appreciate it, thank you. That's all for this record.
Have a good day, Your Honor.
You too. All you criminal lawyers are gonna practice civil. All right, anyway. We are moving on now, sorry for the delay, to docket 23934 FC, People of the State of Michigan versus Jacobo Montalvo. Counsel, your appearances for the record.
Thank you, Sarah Pulled on behalf of the people suit. To my right is the detective on this matter, Ryan Kramer, and to his right is paralegal Sam Corso.
Thank you.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Jake Montalvo, seated to council table as well as Assistant Public Defender John Lee.
And sir, I don't know that you're gonna have anything to say at all, but I'm going to swear you just in case you do speak up, okay? Please raise your right hand. Do you swear or affirm that anything you say in this court will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
Thank you very much. And you had an opportunity to speak with both of your lawyers and prepare for this trial?
Yes, ma'am.
And have you taken any medication yesterday or today?
Negative.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And you are satisfied with the representation that you've received from the public defender's office through these attorneys?
That's a loaded question.
Well, sir, this is a day of trial. I'm asking if you're prepared and if you're satisfied with them. I'm not gonna probably move the trial because I haven't heard anything that you're not satisfied with, but I always make a record. Is there something you think that should have been done that hasn't been done?
Definitely. A lot of stuff. I wrote you 14 letters and you never received one.
Well, because I never received them, my law clerk buried them in his office and we're just finding them. But what's your issue, sir?
It's taken 3 years and 8 months. I mean, this is dragged on. I mean.
Join the club, sir. I can't do anything about that. We have had a number of hearings and I know there's been work in your file. And the club is the COVID club. We've all gone through it, and as a result of that, and the hundreds of cases that were backlogged, and I had 100% criminal docket, so, and I have moved mountains. I think I've heard more cases than anybody in this building to get to everybody. So I'm sorry about the delay, but that is not defensible or reason to set this aside or dismiss this. That's not going to happen. That's an appeal issue. Anything else?
This delay has caused the key witness to disappear, he's had an accident, now he can't remember, he got hit by a car.
Okay, well, I don't have any motion or information about that.
Was my counselor supposed to call it?
Well, sir, I don't know, is there, I don't know how many witnesses, I know that I have a list of about 60 witnesses who could be called. So I don't know that that's the only witness. I believe there are multiple witnesses in this event. I don't know anything about this case. I know very, very little. So, counsel?
Yes, Judge, I mean, I don't want to get too much into it because it does involve case strategy.
Understood.
But I think what he's talking about is, I think we did file a notice of alibi witness, and there was a witness that he's talking about for various different reasons. One of those being that we opted not to call him. I believe we did turn that information over to law enforcement, and I believe Detective Kramer did interview him. And based upon that conversation versus the conversations our office had with him, we aren't pursuing that defense, and I don't think he's thrilled about that.
Okay, so you did investigate that and decided based on the legal theories and the law, it was not wise to call him.
That's correct.
Okay, next issue. Now's the time, sir.
I had Keith Watson as my lawyer. The first year I was arraigned, I had Stephen Freeman. He sat on the case for a whole year, did nothing. I came to court, we fired him with your approval.
Correct.
You told me within 10 days, if I didn't get a lawyer to write you a letter. It took 75 days till I got Keith Watson as my lawyer. Now, he sat on my case for another year, and then the district attorney that we had got a judgeship, so they postponed it more time, and then Keith Watson passes away, and I'm with his co-counsel now.
Well, I'm just a judge on earth. God is the ultimate one, and he took Keith Watson. He needed him for some reason, and he's off your case. There's nothing I can do about that. That's an impossibility. And that just talks to the time delays, all of which were legitimate. And I'm sorry about that, but that's how it goes. So anything legally that I can assist you with that you think that your attorneys have not assisted you with?
I've never got to see them and speak to them face to face and with my counselors. I mean, it's always been through a TV cam.
Because you're in custody, and because that's the way the jail does it these days. You just saw a hearing prior to going on the record here where there was a dozen attorneys. They're fighting over gambling in Michigan. All of them were on Zoom. Since COVID, many, many hearings are on Zoom. In most meetings, even mediations are on Zoom. So I don't think it diminished anything because you had all the time you needed to talk with counsel. You talked with them on Zoom, correct?
Yes, Judge.
Or Polycom, whatever you want to call it.
I've done a number of different things. I'm going to start on a couple of things. Obviously, Mr. Freeman was his first attorney. I don't know what happened, but for some reason or other, he got removed. Obviously, Mr. Watson was the attorney assigned to the case. I've been on this case as long as Mr. Watson's been on the case. And in fact, I was doing 90% of the work on that case. And we've met with Mr. Montalvo every month for the last almost 2 years. And we've met with him at the jail on numerous occasions, not as many as Polycom, but even at the jail, because he's been in isolation, we were not able to visit with him in a room. But we've had numerous communications with Mr. Montalvo. In fact, I would say I've probably seen him more than majority of my other clients, given the longest time I've been on, the amount of time I've been on the case. We've adequately met with him, Your Honor. I understand his frustration with the length of time and the unfortunate passing of Mr. Watson, but as the court knows, I'm well qualified to handle this case. And I do have a second chair here to help assist us with this. I understand his frustration. I'm sad Mr. Watson's not here with me, but as you said, I can't control that.
Anything else, sir?
No, Your Honor.
All right, thank you. On behalf of the people preliminary matters,
Not from the people, thank you.
But I would like to make one other record. I know, I think we may have made this before, but I'd like to at least make sure Mr. Montello understands that this is his choice today to go to a trial and he doesn't wish to accept any plea offers. Is that correct?
Yes, correct.
As a matter of fact, I think on Friday, we talked about a potential plea offer from the prosecutor. Is that correct?
Correct.
Where they were considering offering you murder in the second degree with a fixed term minimum. Is that correct?
That's what you told me.
And
Yes,
you
sir.
wish to reject that offer, is that correct?
Definitely, yes, sir.
Okay, and you understand that your choice with that, is that correct?
Yes, I do.
And this is your choice to do that, is that
Yes, I
correct?
do.
After consulting not only with me, but with Mr. Lee, is that correct?
I'm not guilty and I'm just going to trial.
I get that, just answer the question that was asked. You made that decision after consulting with me and Mr. Lee, is that correct?
Yes,
In fact, we met Thursday after jail, night, is that correct? Last
Yep.
Thursday, and then we met again on Friday over Polycon, is that correct?
correct.
And it's, no one's forced you to make that choice, is that correct?
No,
You wish to exercise your right to go to a jury trial, is that correct?
correct,
No additional questions?
and no one's promised you anything to make that decision, correct?
correct.
All right, thank you.
Your Honor, I would like to clarify as it relates to any discussions regarding plea offers. The plea offer was not set in stone. It wasn't anything that was necessarily discussed in writing or anything to that effect. I spoke with Mr. Feigelson and asked whether or not his client would be willing to discuss plea offers. And he said he could always discuss with his client as it relates to numbers and possibilities in that effect. I said, well, if that's something that you're willing to discuss with him, please get back with me. And then if that is a possibility, I will discuss any potential plea offers with the family. As I understand it, the defendant was not willing to speak about plea offers and that kind of thing. So nothing has been extended from the prosecutor's office.
Well, and we had a final pretrial, so I don't know if I would at this late date accept anything anyway. Sometimes I do, sometimes I don't, but this is an old case and I think we might have had more than one final pretrial on this, but nonetheless. Any preliminary matters other than that?
Nothing, thank you.
The sequestration agreement between council?
That's correct, Your Honor.
Yes, Your Honor, we do have a Detective Lowe in the back. He is one of the detectives on the case, and defense counsel is okay with him being present.
So that my understanding, there were two lead detectives on this case, both Detective Lowe and Detective Kramer, so I think the statute.
So, say that again, they were,
Both, my understanding is they both were co-lead investigators on this case, so my understanding is based on the court rule statute that.
And I would agree with that, but Detective, would you like to come up here? I don't think, because we're gonna introduce everyone and show perhaps we can get him a chair. So you're not sitting with the jury and you can be properly introduced. We have extra chairs. Grab a chair. One of those, I don't care.
you can bring it.
You can give them a more comfortable one. I'm great.
Yeah.
We'll get you a wheelie one that's more comfortable and right. All right. Just put it between them. Great. All right. And jurors are going to be allowed to ask questions or not? Yes. Okay, so we'll make sure that's in the next set of instructions. Are there any other matters we need to address on behalf of the defendant?
I don't believe so, Your Honor, thank you.
All right, on behalf of the court. Somewhere, I gotta grab there it is. All right. I've got my jury binder and I had provided to you the unredacted attorney's list of the potential jurors, and you all had an opportunity to review them. And as I think there's some people we all agree will probably get tossed, but there's no one that you recognize that would be biased or prejudiced right off the bat. So you had an opportunity to review the names. I just want to make a record of that. And then you have there in front of you the redacted names. And we always do it that way, but if you need to see the list at any time. All you have to do is approach and you may review the list.
Thank you, madam. That's correct.
People agree?
Yes, Your Honor.
All right, maybe bring in the jurors.
Yes, Your Honor.
Okay, the jurors, please. And you can do multiple peremptories. Kennedy? Please keep moving up. Keep moving up. Yeah, everybody will get a chair soon enough. Keep moving up. You can make a line right across. Yeah.
We have one more.
You know when you're ready.
Everyone's in.
Nancy, we're ready. Thank you. You may be seated. Ladies and gentlemen, I'm Judge Rosemarie Aquilina, and it's my pleasure and privilege to welcome you to the 30th Circuit Court for Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both the person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 12 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything at all about this case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may be otherwise qualified to be a juror. If you are excused from this case today, then you still need to call the jury hotline all week. The questions may probe deeply into your attitudes and beliefs and experiences. They are not meant to be an unreasonable prying into your private life. The law requires we obtain this information so an impartial jury can be chosen. If you do not hear or understand a question, please say so. If you do understand it, please answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. In a moment, I will ask you to raise your right hand and swear to answer truthfully, fully, and honestly all the questions you'll be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may instead affirm that you will answer all questions truthfully, fully, and honestly. Please raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? Thank you. So before we proceed, there's several other pages I have to read, but I know you're anxious to have a seat. So first of all, we're going to call 14 of you into the box. So I need you to look at your juror number. And then I'm going to ask you some questions before the lawyers get to you, before I read what else I have to say, so we can get those of you who will not be today out as soon as possible. And we're going to start with juror seat 7. As to juror seat 7.
Sequence number 165.
Yes.
Seat number 7, please. Sequence number 133. Seat number 6. Sequence number 87. Seat number 5. Sequence number 38. seat number 4. Sequence number 243, seat number 3.
Kennedy?
Sir,
you have to go up.
Be in seat 5.
Sequence number 23, seat number 2. And sequence number 28, seat number 1.
And now beginning with 14.
Sequence number 104, seat number 14.
Just one moment. You all need to.
I think we
move
down
down
one
one
slide down one there. So.
Yeah.
Right. Sequence number 36, seat number 13. Sequence number 140, seat number 12. Sequence number 151, seat number 11. Sequence number 282, seat number 10. Sequence number 284, seat number 9. And sequence number 20, seat number 8.
We don't have.
9 did come up?
9 would be 284?
Yes, did 284 come up?
No, just coming up now. Now we have empty seats. Please, if you're sitting next to an empty seat, raise your hand so people standing can take a seat. Okay, I have a lot to read to you, but I like to start by asking a couple of questions. And I will do this more in detail as I get through these pages I have to read. This is a case against the people of the state of Michigan versus Jacobo Montalvo. And we'll introduce counsel and Mr. Montalvo in just a moment, but the charges against him, and he has pled not guilty. The charges are count 1, homicide, open murder, and count 2, unlawful imprisonment. If this will be triggering for anyone, I want to know, because I need you to listen with an open mind throughout the case and not have decided anything or not be so upset that you can't listen. And I do know in our community and around the globe, but sadly in our community, everybody knows someone who has lost their life through not natural causes. So if hearing this case will be triggering or upsetting to you because of something you've gone through, please let me know. If additionally you think because there's 2 charges, he must have done something, and you already have some bias against the defendant, then I want to know that as well. So in the jury box, is there anyone who can't be fair and impartial? Juror 8, what is the issue?
I was a witness in a homicide case in Saginaw County about 20 years ago.
And so will you bring something on that case into this case, or will it upset you, or do you think you can be fair and impartial?
Yeah, I watched that person murdered in front of me. I don't think I can go through that again in my life.
Okay, so it would be, you would bring that here, you can't be fair and impartial.
No.
Okay,
I'm shaking just thinking about it.
okay. Any objection, counsel?
No, Your Honor.
No, Your Honor.
Thank you, sir. You're excused. Remember to call the jury hotline. As to juror seat 8.
Sequence number 152.
And as seats empty, please sit down. Any question to those seated in the jury box? Will listening to this case be bothersome for you, or do you think that because there's 2 charges, you must have done something? Anyone? Seeing no hands raised. How about on this side of the room, or with any of you standing in this side of the room? Is there anyone who has an issue listening to this kind of case, or who's already made up their mind? Please stand and give me your juror number.
7.
And what is the issue? You're familiar with it? All right. And what, your number was 7?
Yes.
You're excused.
Your Honor, I'd like to voir dire a little bit more. I want to
Alright.
understand how she's too familiar with it.
Well, without,
I'd like to know
careful
how,
with your questions.
how are you familiar with this matter?
The newspaper. Lansing State Journal.
Okay, and how many articles have you watched? You looked at 2 articles? And
Is there anybody else who needs to say something?
Yes.
do you know any of the parties involved?
I do not know any of the parties involved personally.
Your Honor, I don't know at this point in time, just with the very brief voir dire, that looking at 2 articles would make a person biased to the point that they could not serve as a juror in this case. I understand the articles put out some information, but that would essentially take away our entire jury pool.
Not necessarily. Ma'am, so by reading those articles, have you made up your mind of how you would vote?
I also do not believe I could personally, emotionally handle the evidence that would be brought forth. I'm very, very sensitive about pictures and things like that.
So can you be fair and impartial in this case? Given what you've read and how you feel about it right now, can you be fair and impartial? That's question 1.
No.
And if I had to ask you to vote right now, what would your vote be?
Guilty.
You're excused. Any objection?
Then I'm the defense.
Thank you. Anyone else on this side of the room have any issues? All right, how about on this side of the room? Anyone standing? All right, have all the seats been filled? During jury selection, you may be excused from serving on the jury in 1 of 2 ways. First, I may excuse you for cause. That is, I may decide there's a valid reason why you cannot or should not serve in this case, and you just saw that happen. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a peremptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel badly or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. We think that this trial will last approximately 2 weeks. It may be less. We don't think it will go longer than 2 weeks, but I really have no way of knowing. If you believe the length of trial will be a hardship, not an inconvenience, I also want to know that. I appreciate it's an inconvenience. There are always people who do not show up for jury duty. And probably a few of you thought, oh, I wonder what would happen if I didn't show up. Well, here's what will happen to those who didn't show up. There's a bench warrant that's issued. They get an Uber sheriff ride. They get a hotel stay in Mason. If they're lucky enough, they'll have their choice of colors of jumpsuit and some Crocs to wear. Few good meals. Then they're brought before a judge. They're given a hefty fine unless they have a really good excuse like they were in the hospital. And then they still have to serve jury duty. That's how important you being here is. So on behalf of counsel, all the parties, and the court, we thank you for taking this time and the inconvenience. What I am looking for is a hardship. So let me tell you what we think our schedule is. Today, you'll be done as soon as we pick a jury, and we'll work through the lunch hour, and we'll give you a couple of breaks. If you need to eat something, there's some food downstairs, maybe you brought something, but what I find is if I give you a lunch break, it'll take an hour and a half or 2 hours, and then you come back, and then we're only here for half an hour. So we're pretty good at getting people out of jury duty, or out of the picking a jury, I should say, quickly. So, but you'll be done for the day once the selection has been made of the 14 jurors. Tuesday, we will work 9 to 5, Thursday 9 to 5. We will not work this Wednesday or next Wednesday. We will work Thursday and Friday 9 to 5. Monday, Tuesday, Thursday, next week, actually Monday is 9 to 5, Tuesday is 9 to 2, Wednesday we will not be here, Thursday 9 to 5, and Friday 9 to 4. That's if the case is not concluded. Let's suppose the case concludes on Monday. There is no time frame on deliberation. I've had jurors who deliberated for only an hour, but I've also had jurors who have deliberated for 5 days. So I simply don't know how long. I have to trust the lawyers. They know their case much better than I do. I hardly know anything about this case because some defendant might want a bench trial, so I don't even get police reports. So I rely on the lawyers, and they told me they think about 2 weeks. It may be sooner, but I need those of you who have a hardship. For example, you might have a work conference in Florida next week, or a vacation next week in Florida. That would be a reason. That would be a hardship. Some of you may have a financial hardship. You're the sole breadwinner, and losing a week or 2 of work would put you out on the streets. We don't want that. If you're a nursing mother, the law provides you don't have to be here. So I need to know if you think this will be a hardship. In the jury box, is there any hardship based on the length of time? Juror 9, what is the issue?
I do not make enough, or I will not be able to make enough if I lose a week or 2.
Financial hardship?
Yep.
Your excuse, would you like to call the jury hotline every night? Juror 11.
Same reason, financially, I'm the head of the household, and it'll be hard on me.
You're excused. Counsel, if you have any objection, please let me know. You're excused. And juror 8.
We have a family vacation planned over Labor Day weekend.
So do I. We'll be done by then or on vacation and continue after that. Okay. Okay, we're on the same page. Okay, juror 5.
Same thing, I'm going on vacation on the 13th.
On the 13th, you're good. We will be done by the 13th. Okay. Anybody else on this side of the room? Okay, please stand and I'll need your numbers.
57. My husband's a quadriplegic and I'm a caregiver. I didn't bring my FMLA leave.
You're excused. You'll still have to call the jury hotline, but in the future, if you get a doctor's note, you may be exempt for that period of time. All right, you can talk to Gloria downstairs about that. Ma'am, what is your number?
178. 178.
And what is the issue?
I have to work or I won't be able to pay my bill.
You're excused. Man in the front here, what is your number?
11. I'm not paid if I don't work, so I won't be able to pay those.
You're excused. What is your number in the green shirt?
273. I'm having special needs and I have to be there for him for school starting up this week. To get him through and I'm the sole person.
You're excused. Sir, what is your number?
258.
And what is the issue?
I am the sole provider at home. Without work, I'm commission sales, so if I'm not at work, I don't think anything at all.
And you'll have trouble paying your bills?
Yes, ma'am.
You're excused. In the back there?
I'm her number 264. Yesterday, someone in my family passed. I'm helping make a
No,
funeral.
I'm terribly sorry. You're excused.
290. I am the only single parent. I need to get my kids to school. Are in Northwest Corporation. So,
I didn't hear the rest of that.
I drive my kids to school. They don't have bus access, so school and I don't have any other support to get them there.
So what time does their school start? So you can be here by 9? Okay.
I just had to be here at 7:30, so
Yeah, today's special because they have to read you a lot of rules and things, so it won't be, I won't be here at 7:30, I promise you.
Okay, so I can be here by 9.
Okay, and then do they have aftercare?
No, we don't.
So what do you do with them after school?
I mean, I work at the school, so I mean, this is the first week of school, so I would be able to take them home. But I don't have anything planned for after. So I would have to make arrangements with someone.
Is that something you can do?
I could try.
Okay, have a seat. Ma'am, what's your number?
100. I have a 5-month-old at home. I'm a stay-at-mom and my husband gonna take off for 2 weeks to watch him. And I can't pay for it in daycare.
So financial hardship, you're excused. There's seats that are empty, so please, those people who are standing, please take a
Your
seat.
Honor.
Yep. Well, I get to. Were there anyone over here? All right, sir, what is your number?
65. Paycheck to paycheck.
You're excused.
Thank you.
Yes, sir, what's your number?
252, financial hardship, I'm the sole provider. I have to take today off to come in here.
You're excused.
Thank you, ma'am.
What's your number?
9.
9?
Yeah.
And what's the issue?
Bad vacation from the 1st for a couple weeks.
Okay, so as of next Tuesday, you're excused. All right, how about this side of the room? And do you have can you take a seat or do you have something to talk to me about?
No, I'm the last one.
You're what?
There's
seats, yeah. All right, and what is your number?
182.
And what is the issue?
A couple reasons. I'm coming off a 2.5 month layoff and I just started a job last week. So I don't know about the probation period.
So, well, that's a really good question, something I get to, but I'm gonna get to right now. So none of you can be fired for, or laid off, or nothing can happen to you through your employer because you have jury duty. And in fact, there was a doctor's office a few years ago where the manager of the office fired the person who had jury duty. That person filed a suit against the doctor. How do you think the jury rules? The doctor learned a lesson, and so did a lot of people. So they cannot take any action against you. But I think the larger question for you is, because the employer could not do anything because you served on the jury. The larger question is, having been laid off for so long, is this a financial hardship?
Very.
You're excused.
Thank you.
Ma'am, what is your number?
It's 207.
What
For the
is the
same
issue?
reason, financial hardship. So I'm a single mom. I work nights, 7 days a week.
You're excused. Okay, here, and that brings up another issue. How many of you work third shift and you think you can work third shift and then come in here and listen to all the evidence? Well, I see a few third shifters. Okay, so please stand, sir. Let's have a conversation. Let's have a conversation. What is your number, sir?
93,
Okay, so how long have you been working third shift?
2 years.
And is your body attuned to that third shift cycle?
Yeah, getting here today was a little tricky, but I figured.
So do you think that you could stay awake for 2 weeks and shift your body, or would that be tough for you?
I would enjoy that challenge.
You'll enjoy the challenge, okay. Well, we might not enjoy it, not pay attention to everything, so I don't want you to fall asleep, so, and you can't work.
Right.
You just can't, you're gonna have to sleep and then wake up kind of like a normal schedule.
Right.
So do you think you can do that?
That would be tricky, especially as I go back to it right after. I work 6 days a week, so.
You know,
I think I could, but I do not know that I would be the best candidate.
All right, for now, I'm gonna leave you, we'll have counsel further question you, but I do have concerns about you, sir. All right, ma'am, what is your number?
105.
105? And how long have you been working third shift?
I just started my new job last week.
Oh, okay. So you could then make the transition. So you can serve and then not go to, I can't even go to work and then be here.
No, I have to be at work at night, so.
Not if you're doing jury duty.
Oh, okay, so I can just let them, I mean, I let them know that I have to come in today, but I'm expected to work tonight, so.
Here's the problem. You work tonight, are you working a 12-hour shift?
No, 8.
Okay, 8-hour shift. What time do you finish?
I finish at 7.
So 7, so you might sleep for an hour, hour and a half, or maybe you'll have a bucket of coffee, I don't know. Then you're gonna be here from 9 to 5. Can you do that and pay attention? No. So what I need you to do is either not go to work and come here. Can you do that?
I don't think so this early, because I asked them if they had any accommodations for me, and they just said to go to jury duty and come to work at night, so.
Well,
this is a new job, so I still don't know a lot of things.
yes, well, the law is they can't make you do that.
Okay,
So-
so I can tell them that's the law.
You can't be fired or admonished because of jury duty, and I don't think it's feasible for you to stay up all night on a job and then come here and stay awake. So, but I'll let the attorneys further question you, so have a seat. All right, anybody else? All right, please stand. How long have you, what's your number?
84.
And how long have you been working third shift?
8 years.
A year?
8 years.
8 years? Wow.
8 years, yeah.
What do you do?
I'm a nurse.
Okay, wow, okay. So you're really busy at night. Can you shift your schedule so you're not working these couple of weeks and then?
I'd be able to, yeah.
Okay, thank you, have a seat. All right, great. So this is an instruction, I usually read the next set of instructions once you are chosen. However, I've learned to read it now. I don't know what other judges do, nor do I care. I've had situations where we take a break, and now that everybody knows defendant's name, and we've heard from someone who said there was a couple of articles in the Lansing State Journal, now everybody takes their phones and they start, I want to read that article. No. You will only get information about this case when we're all together. So you are not allowed to talk about the case in the hallway, to talk about any witnesses, attorneys, or anything to do with this case. The charges, anything you may remember reading or the location, anything. So the restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it's crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side or the other. These restrictions continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. So while you are in the hallway, in the courtroom, in the restroom, as long as you're acting as a jury pool and beyond until you're discharged, you cannot discuss or do any research. That means you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You must also not research any aspect of the case, and that means using a cellular phone, iPad, computer, AI, chat GPT, or any other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, which you probably didn't bring with you, but to make the point, newspapers or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phone, computers, or other electronic devices. We have had people go out in the hallway and start chatting with AI or chat GPT to ask about different crimes and different things, and no, you cannot do that. Please refrain from doing that. If you do learn something, please let us know, or if you hear someone talking about it, please let us know, and do not share any information about the case by any means, including cellular phones or social media. We've also had people who say, oh, that's great, look at what I'm doing, and they're doing live streaming on, as they're being a jury and talking about the case, and then putting it on Instagram or what have you. So TikTok, please don't TikTok this case. And do not make any posts about this on social media websites of any kind or in any other manner. If you discover a juror or potential juror has done this and violated my instructions, please report it to staff at once. You've met some members of my staff already. My clerk is Diane Chillers, and she's the one that called the numbers into the jury box. And my court reporter is Nancy Renke. She's my silent partner. She is the one who takes down every single word. And Diane does all the paperwork that goes along with this case. And so it's really important that you use words. So don't do a nod, yes or no, because Nancy would have to guess at what you meant. So you have to use words that could be found in the dictionary. It's okay that you nod, but we're gonna ask you, are you saying yes or no? So, or if you do, mm-hmm. In America, we talk with a lot of grunts and groans and hand gestures and head nods and all of that. That makes a really bad record because it would be blank. So I need you to use words that can be found in a dictionary. My law clerk and jury bailiff is Kennedy Parker. She's the one that lets you in, and she's assisting you, and she assists the court. So if you have a question, if there's something you need, please ask her and she will get you the answer. Now, this is a criminal case involving the charges of homicide, open murder, and unlawful imprisonment, which I will explain more fully later. These charges have been made against the defendant, who is Jacobo Montalvo. Counsel, please introduce yourself and your client. You all three can stand.
Good morning, ladies and gentlemen of the jury. My name is Steve Feigelson, and I have the honor and privilege to represent Jake Montalvo, standing to my right this morning, as well as an attorney who's helping me with this case, John Lee. I also have Mike Taylor and Kayla Douglas, who are part of my office staff that will be here.
Thank you. The lawyer for the state of Michigan is Chief Assistant Prosecuting Attorney Sarah Polna. Counsel, please stand and ask, and everyone at your table stand, please introduce them. And then after you've introduced them, they can have a seat, and you could please name the witnesses who may be called.
Good morning, everyone. I am Chief Assistant Prosecuting Attorney Sarah Polda, and I am proud to represent the state of Michigan in this matter. Standing to my left is Detective Brian Kramer of the Ingham County Sheriff's Department. To his left is Detective William Lowe from the Ingham County Sheriff's Department. You'll see him here coming and going. And then to his right is Samantha Corso. She is a paralegal with the Ingham County Prosecutor's Office. The witnesses that we have scheduled in this matter are Rachel Hidalgo, Joseph Thibault, Stephen Geik, Deputy Adam Jackson, Officer Zach Vanderwerf, Deputy Detective Nate Olson, Officer Caitlin Markey, Jermaine Ware, Detective from the Sheriff's Department, Megan Jordan, Detective Ryan Kramer, Deputy Joseph Canwas, Deputy Jason Hedger, Christina Rasmussen, Tara Kramer, Dr. Michael Markey, Rebecca Ray Madden, Amalia Almazan, Marsha Porter, Peggy Ruiz Helmick, and Detective William Flo.
Counsel, I have a question. I have listed as Deputy Jacob Hedger. Is it Jason or Jacob?
It's Jason. I'm sorry. That must have been a typo on me.
Okay, no problem. Just want to make sure I get it right. All right, on behalf of defendants, does either counsel wish to list any additional witnesses you may call?
None at this time, Your Honor.
Thank you. Now, does anyone know any of the counsel, detectives, defendant, counsel for defendant, or any witnesses who may be called? All right, in the jury box, juror 8, who do you know?
Rachel Hidalgo.
And how do you know her?
We attend the same church.
And when was the last time you saw her?
Just Sunday.
And have you had conversations about this case at all?
I have not personally, but when they said her name, I think that there's been discussion.
Okay, and can you be fair and impartial based on what you recall or what you think you heard? Can you still be fair and impartial, listen to both sides, and then decide the case with your fellow jurors?
I think I could, but I also think that I could be very uncomfortable in my life afterwards, depending on the outcome of the case. You know, just knowing a person that's been affected by it.
Yeah, so is that troublesome to you? Is that going to affect how you decide the case? Well, let's say this is an uncomfortable situation.
Yes,
I mean, I do this every day, so does counsel. You all don't, and it is tough to make a decision against your fellow citizen. I mean, there's a lot of information here. Some of it's gonna be tough to listen to. And I know it's something new for you, okay? But the issue is, can you listen, pay attention, be fair and impartial to both sides, and then decide with your fellow jurors what happened? Because I decide the law, and you all decide what the facts are. So you'll have to sit at this table in this very small room and discuss what you've heard and seen and decide the facts. Can you do that and not worry about what might not even ever happen in the future?
I believe I can.
Okay, thank you. Anyone else in the jury box? Over here, I saw a hand. Would you please stand, those of you who, all right. Sir, what is your juror number?
It's 124.
And what is the issue?
I work at the Michigan Supreme Court at scale. I work often with Peggy Ruiz Helmick, probably on at least a bi-weekly basis. I know her to be truthful and honest. And I also a professor of mine several years ago, only a couple.
You're aging me.
No, no. And And I don't know, now is the time. I know Ms. Ruiz Helmet to be truthful, honest. I would very much weigh what she has to say in a favorable light because of how I know her.
So you'll give her greater weight already without having heard anything?
I think that's probably human nature. I probably.
So if she said something that didn't quite fit with the rest of the puzzle pieces, right? If you look at this as a puzzle and what she says doesn't quite fit, could you then discount it and look at it in a different angle than just it must be true?
I would do my best. I don't know if I'd be able to fully extract the personal relationship and how I know her to be. I don't know if I could do that well.
Okay, so if I asked you how you would decide this case right now, what would your answer be?
Well, I guess I don't know if she's the prosecution's witness. I'm assuming she would testify to support the prosecution's case. So I believe it would.
Do you, and you understand that people can see and hear things differently from different angles? So while she might be at one angle, someone else might be at a different angle. Can you use your common sense to figure out what fits the theory of defense or prosecution best?
I think I probably could.
Have a seat, thank you. Please.
Number 201, I know Detective Ryan and your court officer. I spent 20 years law set sheriff myself. My nephew was murdered in a alcohol accident 10 years ago. And the individual that is charged got a very light sentence because he spent a little too long in jail. So I think I can be impartial, but I felt you needed to know that I was part of the sheriff's department.
So will you bring that situation, and I recall that. Will you bring that situation into this case, or can you be fair and impartial?
I think I can be fair and impartial.
I appreciate you bringing that up. I'll let the lawyers further question you. You may have a seat. Anyone else on this side of the room? How about on this side of the room? Please stand and give me your number.
Hi, I'm number 33. I work at the College of Law at MSU, and I've worked with a lot of attorneys, since I didn't know people were bringing because they work in like legal areas. I thought I should let you know.
I work there too. Nice to meet you. So based on what you know about the lawyers and the law, can you be fair and impartial? Can you leave what you know about the law, the legal field? Can you leave that outside of this and just listen to the facts here and decide it with your fellow jurors?
I believe so.
Have a seat, thank you. And sir, what is your number?
48.
And what is the issue?
My wife currently used to work at the County Prosecutor's Office, so I'm familiar with a couple of detectives that are on the case.
Have you talked about this case with anyone in the prosecutor's office or any detective? Can you be fair and impartial to both sides? Thank you very much. Thanks for letting us know. Have a seat. Ma'am, what is your number?
179. I've worked with the attorneys over on this side for defendant before under Chapo.
And can you be fair and impartial after listening to the evidence, or will you weigh their side better than the prosecutor? Will you favor one side or the other?
No.
So you can be fair and impartial? Appreciate letting us know. Have a seat. All right, so some of you may have issues like you can't sit for an hour and a half to 2 hours. We all get tired. We all need to use the restroom or have a new cup of coffee or whatever. So we take breaks about every hour and a half or 2 hours at the most. Is there anyone who can't sit for that long? Is there anyone who's on medication who doesn't sleep at night so then you're tired during the day? Or I had somebody in here who was in remission from cancer but had a morphine drip, and we just couldn't allow that. Is there anyone who has some kind of medical issue where it would just be tough to pay attention to this or sit for that long? And I don't need to know your whole history. I just need to know what the issue is. And if there is something you all want me to know, but you don't want to say it publicly. All you have to do is let me know that, and then when we take a break, we'll bring you in here with only necessary court personnel. So in the box, is there anyone who has a medical or other issue that you want me to know about? Seeing no hands, how about on this side of the room? All right, please stand and give me your numbers.
One, I have an issue that I would like to not discuss in front of the group if possible.
Okay, have a seat, we will get to you. Ma'am, your number?
78. I would need to talk to someone as well.
Okay, have a seat. And anyone else? Okay, sir, what is your number?
201. I have a spinal stimulator implanted in my back, so I have a tendency to be kind of fidgety.
Okay,
So, but again, I still don't think that'd be a problem.
I think it's okay, we have some chairs that kind of roll around, and if you need to stand up or whatever, we're used to that. All right, and those of you who take insulin, we're also used to that. We do have a refrigerator, you can bring your food or what have you, so we're good on that. A lot of people raise that issue. All right, how about on this side of the room? All right, please stand and tell me your number.
188. I have ADHD and just ran out of my meds, so it might be a little harder to focus for me.
So are you picking up your meds tonight, maybe?
I have to call my doctor's office and get them refilled, and my insurance just changed, so it might be a few days, but that is in the plans.
Okay, so, I have a son with ADHD, and this summer he decided, he's 16, he didn't want to take his medicine, but he did a lot of exercise and a lot of things, and so his ADHD was fine. Now school starting, he's like, I'm going back on the medicine. And I know there's various degrees of ADHD, so are you able to pay attention and take notes, or are you someone who's gonna wanna run around the room, or I don't know what kind you have, because there's so many variations of it.
Typically, if I have something to take notes with or something in my hand, I am pretty good with focusing.
Okay, very good, so we do have some squeezy balls, I think, and we will give you notepads and you can doodle or take notes, we don't look at what you do, so.
All right, thank you.
All right, very good. Anyone else have any other issues? Okay. Can everybody see and hear, can everybody hear me? If not, we do have, I should have asked this earlier, maybe my law clerk asked this, but we do have some headphones if you're having trouble hearing. Please let us know. Is there anyone who can't hear me? Is there anyone who can't see around the courtroom? All right. Any other medical issues that someone might want to talk about publicly as to why you shouldn't serve? Any nursing moms? Okay, good. As I've said a couple of times, this is a criminal case. The paper used to charge the defendant with a crime is called an information. The information in this case charges the defendant as follows. People of the state of Michigan versus Jacobo Montalvo. That on or about October 16th, 2023, in White Oak Township, County of Ingham, State of Michigan, at a specific location known as Iosco Road near Brogan Road, defendant did, in count 1, homicide, open murder, did murder Alicia, Alicia Gallegos, Gallegos. This is contrary to the laws of the state of Michigan. Count 2, unlawful imprisonment. Defendant did secretly confine and knowingly restrain Alicia Gallegos or knowingly restrain Alicia Gallegos to facilitate the commission of homicide, open murder, contrary to the laws of the state of Michigan. Defendant has pled not guilty to these charges. You should clearly understand that the information I have just read is not evidence. And information is read in every criminal trial so that defendant and jury can hear the charges. You must not think it is evidence of his guilt or that he must be guilty because he has been charged. Now, I hadn't mentioned before the name of the deceased, the victim. Does anybody recognize that name or know her? Seeing no hands raised. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that defendant is innocent. This presumption continues throughout the trial and entitles defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. Defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. At this time, on behalf of the people, are you ready for what here?
Your Honor, we have.
Oh, I'm sorry, I forgot, we have two. Juror seat 11.
Juror seat 11, sequence number 111.
And juror seat 9.
Juror seat number 9 will be sequence number 8.
Just go on there. When you're ready, on behalf of the people, you may proceed.
Good morning, everyone. Again, my name is Sarah Poldock, Chief Assistant Prosecuting Attorney with Ingham County. It's a pleasure and a privilege to be here to have this experience with you. Today is a very important day for you all. It's a very important responsibility as a citizen. The responsibilities of a juror are to remain fair and impartial, and this is our chance to speak with you to ensure that each side, the prosecution and the defense, have a jury of impartial and unbiased jurors. Everyone in this case has a role. The judge rules on the law. She maintains a fair courtroom. The prosecution presents its evidence. The defense attorneys ensure that the defendant has a fair trial and his rights are upheld. And you as the jurors, you are the ones who decide the facts and whether those facts apply to the law that's given to you. As you heard, we do have other people here at our council table. The detectives who worked on this case, our paralegal will be here throughout the case as well. You'll see her. And you just heard from the judge that this process here is the one chance that you and I and the defense counsel will have to speak with each other, because if you are chosen as a juror, that'll be the last time that we'll be able to talk. So this is our chance to learn. There's two rules that I ask that we keep. One, keep all of the questions, this includes everyone here in the gallery, keep all the questions that I ask in mind so that if you do get called up as a replacement juror for anyone in the box, that you can let me know if you have an answer or something sticks out in your mind. And second, there are no right or wrong answers. This is our chance to get to know you better and to know whether or not you'll be the right juror for this case.
Leave your
Now,
house and go out into the world. Financial literacy. And I don't know about you guys, but I got about 2 months in my senior year of high school.
Siri, just let me turn it off. Thank you. Sorry. You may proceed.
Thank you. Now, if you're not chosen as a juror in this matter, don't be upset. You might actually be happy. But it's not anything, no one's going to be mad at you. No one is thinking, well, this person, you know, darn, we can't keep them, or whatever the circumstances are. It's just the way that everything goes. And we want to make sure that you're very candid with us about your background, background, your thoughts, your viewpoints, anything that you believe is relevant to this case, and what makes you, either a good or maybe not so good potential juror in this case. So I want to give you just a rundown of what this case is so that I can use this rundown to help you understand what we're looking for in a potential juror. So the rundown of this case is that on October 16th of 2023, the body of Alicia Gallegos was found in the woods, dumped there between Iasa Road near Brogan in White Oak Township, which is out near Stockbridge, off of M52. She was found with apparent strangulation wounds on her neck. And after an investigation, surveillance evidence from downtown Lansing led to the discovery of video of her being forcibly taken off of the street by a man. That same investigation led to the arrest and charging of Jacobo Montalvo. So just keep that in mind, and I want to know whether or not anybody knows or anything about this case, so that might give you a better understanding. Or we heard one juror said that they read something in the newspaper. We want to know that if you've already made up your mind or decided this case beforehand. So what I like to do is give you expectations of what to expect during this jury selection. We're going to be going over 4 different factors, 4 different questions essentially that I'm going to be asking. The first one is whether or not you have prior knowledge of the case or people involved. I know juror number 8, you may know Rachel Hidalgo. Number 2 is what does being a juror mean? Number 3 is that this case is going to involve very graphic evidence. And number 4 is the presumption of innocence and proof beyond a reasonable doubt. So what does that mean and how does that work in this case? So let's start with number 1, and I'll ask you questions kind of individually and kind of as a group, and I'll ask for a show of hands. But number 1, the first thing that I'll be going over is your prior knowledge or memory of this case or the people involved. I know the judge really hit on this with the list of witnesses and that kind of thing, but as a panel, by a show of hands, does anyone remember seeing anything in the news back in October of 2023? I see juror number 11 and juror number 13. So we'll start with juror number 11. Was this something that you saw online or in the news?
Yeah, I worked downtown. I remember seeing it on the news where the pickup was. I lived out in Danesville that time, and I remember some of that through there.
So based on where you lived and where you worked, it just became a little bit more personal to you at that point.
Yeah.
And did you follow the media at that point,
I
or
didn't follow it? No,
you did not?
I
Okay.
did not follow it.
Did you talk about it with anyone?
No.
Were you aware of what the name of the victim was?
I was not.
Aware of who the defendant was?
No.
Okay. Just something that you kind of kept in your mind?
I did. I just, when you said where, I just remember the location of pickup and then where it was.
Okay. Very good, thank you. And juror number 13, you ready?
Yeah, very vague memory, fairly regular reader of news.
Mhm.
I remember the name Montalvo definitely rings a bell, but I don't remember the details or discussing details.
And did you make any decisions or anything about those articles? Now that you're sitting here as a potential juror in this case, how would you describe your mindset?
Open-minded.
Good, okay, and you, juror number 11? Okay. There's a possibility that there will be continued media coverage in this case. I'm not sure, I haven't seen anything come through, but typically in cases like this, there could be continued media coverage. The judge gave you an instruction that said, stay off of social media, stay out of the news, don't watch anything, don't read any articles, because the only thing that you need to be taking into account are the things that you see here in the courtroom, okay? Now, number 2, so we're already on number 2. So being a juror, everyone in this courtroom has their individual jobs. I already talked about that. And the system ends up becoming unfair if we step out of those roles. So if I start controlling this courtroom and telling Nancy, our court reporter, you know, when she needs to stop or when she needs to start or that kind of thing, that's not my position. I handle the evidence. I present to you witnesses. I present to you the case and I make my arguments. The defense attorney will do the same and the judge will do her job as well. Now you, as the jurors, will have to decide the facts, and the judge will provide you this instruction. Your responsibility as jurors is to decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and all the testimony, and then decide what each piece of evidence means and how important you think it is. Now, who on this panel has ever served as a juror before? Quite a few, okay. So, juror number 2. So in the back, what was the hardest part for you in being a juror? If you had one.
Just listening to all the details.
Okay. And juror number 2, what type of a case were you a juror?
As a robbery assault.
How long ago was that?
I think over 10 years.
Okay. Was it here in Ingham County? Right here in this courtroom?
I believe it was right here.
Okay, all right. And you said listening to all of the facts of the case were the hardest part?
Yes, because there's a lot of details and I should have been taking notes when I did, because I thought I would store it. So.
Okay. Did you have a chance to deliberate on that case?
Yes.
And did you come to a verdict in that matter?
Yes.
All right. Now, I believe juror number 3, did you raise your hand?
Yes.
And how long, what kind of a case did you sit?
I've sat on 3 juries.
Okay.
First one was a child molestation, and then that was like 30+ years ago.
Sure.
One was an assault like 20 years ago, and one was a mistrial, a drunk driving case that was 10 years ago.
And did you have to listen to witnesses testify in those cases?
Yes.
And as you being the juror, did you have to assess those witnesses' credibility? Do you know what I mean by that?
Yes.
Okay. And tell me about your thoughts on that. How did you decide who to believe and who to not believe?
I tried to just listen to the facts.
And determine what made sense?
Yes.
Okay. Was there anything that you liked or disliked about that process?
The first case was a little tedious because there was a lot of evidence presented, carpet fibers and things.
Sure.
But that's what I think.
Okay. And I had a couple of other jurors in the front, I believe. Raise their hand. Juror number 8, you were on a jury as well?
It had to do with a threat with a weapon.
A threat with a weapon?
Yeah.
Okay. And how long ago was this?
Probably 10 years.
Did you have any concerns of sitting on a jury back then? The only concerns that you have maybe in this time around are the fact that you may know Rachel Hidalgo? Is that a yes?
Yes.
And are you sure that it is the one in the same Rachel Hidalgo as the witness here?
Well, if this is her daughter that was murdered, then yes.
Okay. Juror number 9, go ahead.
I did as well, just over 2 years ago, a child sex abuse case,
Was that here in Ingham County?
right here in this building.
All right. And were you able to take the case to deliberation?
Yes.
What were your thoughts on deliberating with 12 other strangers?
It's more difficult than you think.
Mm-hmm. What was the most difficult thing about it?
Just coming to a final decision.
And
And executing that decision, basically, more difficult than you think.
all right. What are your thoughts on potentially being a juror this time around?
I guess
Indifferent?
I understand the process. I feel like it's a duty.
Okay. And anyone else that had their hands up? Did juror 12? Yes.
A domestic violence?
All right. And was that in the district court?
Yes,
Okay. And how long ago was that?
just last year.
What were your thoughts about that circumstance?
To be honest, that was just more like a violence towards defendants.
You felt it was more violent toward the defendant?
Was that?
Did you
Yeah,
say,
yeah.
okay, and, is that something that you believe is more prevalent, or was it just that case?
Not just that case.
Oh, I understand, okay. And, back then, you would have had 6 jurors, is that right?
Yes.
And now there's going to be more. What are your thoughts about potentially being a juror of 12 instead of 6?
Well, with more jurors, I think we could probably come up with more ideas, come to a close case.
Sure. Anyone else that I missed? Anyone on the panel have any kind of issue of essentially, and I know that the other people that have been jurors understand this already, but as a juror, you essentially have to come down, what this boils down to is you have to decide facts of the case that will essentially make you be in judgment of another person. So you have to render a verdict against another person, whether it be one way or the other. Does anyone have any beliefs or morals that may prevent them from standing in judgment of another person or anything to that effect? All right, seeing no hands, thank you. The third thing that I would like to go over is graphic evidence. Now, this case, as you've heard, is a homicide, open murder. There is another count of unlawful imprisonment. You heard from my rundown of the case that there is surveillance video. We will have a doctor on the case come in. He's a forensic pathologist. We'll be showing photos. A lot of the videos that we will show follow the victim, Alicia Gallegos, around town. She has everything that I've seen and everything that I've heard, what appears to be a significant drug addiction. There's going to be evidence of drug addiction, and that may be very difficult for some jurors to listen to or to deal with maybe in their personal lives, depending on what they have going on with their family or personally or that effect. Anyone on the panel right now have any issue with seeing or hearing any type of evidence that may have anything to do with drug addiction? Nothing? Does anyone in the on the panel have any close family members or any friends that have ever dealt with drug addiction? Juror number 7, tell us about that.
A number of family members have dealt and overcome drug and alcohol addiction and work in the field professionally.
That work in the what?
I work in the field
Oh.
professionally, drug and alcohol addiction.
I understand, and you are a social worker?
Yes.
What, in what realm do you work?
In administration now, but both mental health and substance use disorder treatment.
Okay, and is that here in this area, in the greater Lansing area?
I work in the Jackson area now, but primarily in the Lansing area.
All right, and did you recognize Alicia's name at all?
Yes.
Okay.
I think as the wheels turn a little bit, like I've seen so many people over the years, but like family rings a bell.
Yeah.
I don't really recognize any like specifics.
It's one of the reasons I kind of give the overview of the facts without being too detailed. It kind of brings back memories for people often if they kind of hear what happened. So in thinking back and potentially remembering this person, based on what your career path is, do you think that you could be fair and impartial as it relates to this case?
Yes, I can be fair and impartial.
Okay. How often do you work directly with clients nowadays? You said you're in administration?
Probably like every day.
Okay.
More or less, yeah.
And what do you do specifically with these clients?
Like mental health counseling, substance abuse counseling.
And I saw one other juror, I believe, raise their hand. Yes, juror number 8.
My nephew was, involved in drugs really heavily in heroin addiction. It's been about 10 years ago that it was really bad, but he's totally turned himself around.
I'm glad to hear that. Anything about this case that may affect you at all?
Not drug related.
Okay, all right. I saw another juror just raise briefly. Yes, juror number 10.
My dad, was addicted to alcohol and to pills.
Okay.
But he's been sober 7 years.
Anything about potentially being a juror in this case that may affect your ability to be a juror?
No.
Anyone else? Now, juror number 8, you said that your nephew was pretty severely addicted back around 10 years ago. How often did you talk with the your family members about that addiction?
Probably not constant. I wasn't involved in it so much, you know, I mean, my sister-in-law was concerned about him, but I wasn't involved with trying to get him off drugs and didn't see him that much. Didn't see him a lot when he was on drugs.
Right. Did you ever hear any stories about him putting himself into situations that probably wouldn't have happened if he was not addicted?
Mainly, it was just his lack of responsibility with his children that, you know, not being involved in their lives and not providing for them.
Juror number 10, anything that you could add to that regarding your dad?
No.
And juror number 7, I'm sure you've probably heard of a lot of clients that have put themselves in situations that probably wouldn't have happened if they weren't addicted. Is that right? Yeah. The last thing that I'd like to go over with you is the presumption of innocence and proof beyond reasonable doubt. And the judge will read to you an instruction that states that a person accused of a crime is presumed to be innocent. That means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Now, juror number 3, you've been a juror probably the most out of all of the jurors here on the panel. If you were chosen as a juror in this case and tasked with finding the defendant guilty beyond a reasonable doubt, does that mean that you have to find the defendant to be 100%, will you have to be 100% certain of the defendant's guilt?
No.
Okay, tell us more about that. What does that mean to you?
I mean, unless you were there personally, there's always gonna be something, there's always gonna be a little bit of doubt. And in the first case, we did find
Hang on.
the.
Jackson, I don't think she can get, she's about to get into the verdict. I don't think we can get there.
Can you please provide some case law? I don't know what prevents her from saying what her verdict is if she's volunteering it.
Well, I don't think we need to know the verdict. Without telling us the verdict, can you answer the question?
In the first case, when we found the verdict, yeah, you always think about, well, the consequences of the defendant, but as it turned out, we made the right decision.
Mm-hmm. And essentially, as a juror, the only way that you would be.
The only way you would be 100% sure is if you were actually there.
Absolutely. You just answered all my questions. I don't even have anything left. Juror number 4, tell me something that you're 100% certain about.
It's hard. I really don't
Yeah, I had one juror say to me during that question, and this is the only time that it's ever happened, she can be 100% certain that the sun is going to rise every day, and I didn't have an answer for that. So I was like, yes, I'll have to move on from that question, but can you be 100% certain that you're serving as a juror right now?
Yeah.
Okay, have you ever see that show that you've seen online or on TV that is the show about the guy that got duped into becoming a juror and it really wasn't anything? Yeah, I use that description often too. But essentially what this boils down to is that 100% certainty about anything is proof beyond a shadow of a doubt. You can have reasonable doubts here as jurors. The judge will give you the law that says it's only proof beyond a reasonable doubt. And just as juror number 3 said, the only way that you as a juror could be 100% certain of the defendant's guilt is if you were there watching him do it, or whoever you're a juror for, you'd have to watch it happen and be present. And then if that was the case, then you'd be a witness in the case and you couldn't be a juror, right? So that's why the law states that you as jurors only have the burden to show beyond a reasonable doubt the defendant is guilty. Now this goes also into the second portion of my question is how do we prove guilt beyond a reasonable doubt? Well, we do it with evidence, and there's 2 types of evidence that we use, and we use direct evidence and circumstantial evidence. Now, juror number 9, you said that you were a juror before and that it was not too long ago, but did they talk about direct evidence and circumstantial evidence in your case?
Did you mean me?
No, juror number 9. Okay.
More direct, I believe.
More direct. Can you give me an example of what direct evidence is? Was it the witnesses that were present?
Yeah, witnesses, yeah.
Yeah, that were present and saw things happening or heard things happening? And do you remember them using any circumstantial evidence?
Not that I recall.
Okay. You said you were a juror in a child sexual assault case, was that correct?
Correct.
Okay. And did they use any DNA evidence or anything?
No.
Okay. Juror number 9, did you hear any evidence in your case, or I'm sorry, juror number 8, I'm looking at you, juror number 8. I see number 9 literally right underneath you. Juror number 8, did they use any DNA evidence or fingerprint evidence or any forensic evidence in your case?
No.
Okay. Juror number 3, I know that they did in your case, in that first case, they used carpet fires, is that correct?
Yes.
Okay. Did they use any DNA evidence or anything like that in your cases?
I can't recall, it was quite a while ago.
Okay. Juror number 1, we haven't talked yet, but what are your thoughts on DNA? Would you believe that DNA evidence would be considered direct evidence, something that we see or hear or observe personally, or would that be considered circumstantial evidence?
Direct.
Okay. Circumstantial evidence is actually evidence that is normally or reasonably leads to other facts. So, for example, if you see a person come from outside and they're like wearing a raincoat and it's covered in droplets of rain, then you can reasonably believe that it is raining. There's circumstantial evidence that it's raining outside. So when we see and hear about DNA evidence, are we going to have anyone that's going to be able to come in and say, I saw person X place their DNA on a tiny object at the scene of the crime? Will we be able to have that person that can see microscopically that happen?
I have my doubts.
Okay, I do too. And the only way that we can find DNA evidence is by taking swabs and analyzing them in machines and having the machines tell us the information that the DNA can provide us. So technically, DNA evidence is circumstantial evidence, and circumstantial evidence can lead us to making decisions that help us prove guilt beyond a reasonable doubt. What about juror number 1, fingerprints?
they're as good as they're. I mean, I have doubts on how they're collected, how they're processed.
Sure.
I don't know anything about the fingerprinting process.
Sure, but would a fingerprint be considered a direct evidence or circumstantial evidence?
Probably direct.
Okay. Can you tell that I just left a fingerprint right here with your eyes?
Yes.
You can see my, oh yeah, you can. You gotta call me. All right, that'll give you that one. But in the circumstance where maintenance is really great in this room, could you see me putting my fingerprint right here? If it was just a perfectly clean surface?
Can I see it?
Sure. Can you see all the ridges and all of the
Probably not,
different?
if you had a clean surface, probably.
Yeah. So a fingerprint would be considered circumstantial evidence. Just because it's not something that someone sees or hears directly happening doesn't mean that you have to discount it, that it's not worth what it is. You can use circumstantial evidence to help prove a case. And often that's what you see on TV. Juror number 14, do you like to watch TV shows like CSI or Law and Order or those types of things?
I don't actually.
I don't either.
Okay.
I don't either. I can't watch that. Now, you understand what I'm talking about though, as it relates to those TV shows?
Yes.
Is it not amazing that they can solve all that stuff in just 1 hour?
It's incredible.
And how they can do the forensic DNA stuff like within 10 seconds, and it's like they see it in the computer. That does not happen, by the way, but so those TV shows wouldn't be interesting if they didn't have circumstantial evidence, right? Is that a yes? Yes. And if they didn't have circumstantial evidence, they would just have one person saying, I saw the defendant murder the victim, and then the show would be over in 5 minutes and nobody would want to watch it. So juror number 5, what are your thoughts about the things that we've been talking about today?
It's reasonable.
Reasonable?
Circumstance, yeah, circumstance, evidence, you put all pieces together to form a conclusion, basically.
Yeah. Juror number 6, we haven't talked yet, but if I was to wear a raincoat and come into this room and I have rain droplets all over, is it reasonable to believe that it's raining outside if I have rain droplets all over?
Yes.
Yes? Is it reasonable to believe that, what are your thoughts on if the person says, well, this is actually just from the sprinkler outside. I have this jacket, this rain jacket on, I have my umbrella, and the droplets are from the sprinkler outside and it's nice and sunny. Is that reasonable?
Not really.
Not really, because why would the person get up in the morning, put on the rain jacket, get their umbrella, walk outside just to find a sprinkler to get soaking wet to come in here to tell us that they got soaking wet from a sprinkler? That doesn't make sense, right? So that's not reasonable. Those are just some of the things that we can kind of think about when we are looking at facts of cases and determining proof beyond a reasonable doubt. So I think I had a chance to talk to nearly everyone here. Anyone on the jury panel that believes that I should know something about you that may affect your ability to be a fair and impartial juror in this case? Seeing no hands raised, thank you very much for entertaining me and listening to my questions.
On behalf of the defendant, when you're ready.
Yes, Your Honor, thank you. Good afternoon again, ladies and gentlemen of the jury. As I've already indicated, my name is Steve Feigelson, and I have the honor and privilege to represent Jake Montalvo in court this week. I want to talk about one thing, and that's the presumption of innocence and the burden of proof. That burden of proof is on Ms. Polroller. It's her job to prove beyond reasonable doubt that Mr. Montalvo committed the things that he's accused of. Since it's her proof, we don't have to do anything. I don't have to call a single witness. I don't have to ask a single question, because it's her job to prove that my client did it. I don't have to prove he didn't do it. I'm gonna ask you all one simple question. If I were to tell you that's it, case is finished, all you know about the case right now is what you know about the case, which is very little. And I were to tell you that based upon that information, you'd have to find Mr. Montalvo not guilty. How many of you would agree with me? That based on what you know about the case right now, you'd have to find Mr. Montalvo not guilty. Juror number one, would you agree with me? Based on what you know right now, you would think he's guilty?
Doubts.
Okay, why do you have your doubts?
I have to go with my gut feeling.
Okay. I appreciate your honesty, 'cause right now, you start with that presumption, he's innocent until you hear evidence to suggest otherwise. What about you, juror number two? Do you agree with me?
I haven't heard any evidence yet, so.
Your answer would be not guilty right now, is that correct? Probably, what do you mean?
Haven't heard anything yet, so I wouldn't be able to have a verdict.
Right, but we started with the presumption that he's not guilty, so you have to start there. It's not probably not a, I don't know yet, it starts right there, is that correct? What about you, juror number three?
That's correct, not guilty.
Okay, what about you, juror number four?
It's really.
Okay. That's fair, what about you, juror number five?
Not guilty.
Okay. Juror number six?
Same, no good there.
All right. Juror number seven?
Same.
What's your juror number eight?
Not guilty.
What's your juror number nine?
Not guilty.
What's your juror number 10? Juror number one?
Based on evidence, not guilty.
Juror number 12?
Based on evidence, not guilty.
What's your number 13? Juror number 14?
Not guilty.
Okay, thank you. I want you to start there and hold that. Don't want you to make a promise. And that promise isn't to this court. It's not to Ms. Pola. It's not even to me. It's to Mr. Montel over here. And that promise is you're gonna hold Ms. Pola to that burden of proof. Ms. Jordan, are you able to make that promise to Mr. Montal? Will you hold Ms. Pola to her burden of proof? Can you promise my client that, Mr. Juror number one?
Yes.
What about you, juror number two? What's your juror number three?
I will do my duty as a juror and follow law.
What's your juror number four? Do you promise that to my client?
Yes.
What's your juror number four? Five, excuse me. Juror number six?
Yes.
Juror number seven? Juror number nine?
Yes.
Juror number 11?
Yes.
Juror number 12? Yes. Juror number 13? Juror number 14? Let's talk about beyond a reasonable doubt. Court's going to give you an instruction as to what that means, but common sense is a part of that definition. Juror number 6, if I were to select you or people were to select you on this panel, what are some of the things that you would think about using your common sense to help decide this case?
What do you mean?
What are some of the things that you'd be thinking about as you listen to the witnesses testify to help make your decision in this case?
What's the relationship of how he's done it?
Okay. Is English the second language? You able to understand and hear everything? If you, if not, please let us know. Juror number 9, do you have anything to add on it? Juror number 14, been relatively quiet.
I think that you listen to the facts and portion.
Okay. Anyone else have anything to add on what they would use if they were selected on this panel? We talked about credibility of witnesses. You're gonna hear a whole bunch of different witnesses get up and testify through the course of this trial. What are some of the things, juror number 12, that you would think about judging somebody's credibility? Let me ask this. Let's say a witness came under the stand and was wearing shorts and a cutoff T-shirt. What would you think about it? How would you assess their credibility? Okay. And what if somebody walked in, $1,000 suit, and looked very fancy? How would you assess their credibility? Similar or different?
Different.
Okay. That was before they even said a word, is that correct? Yes. Okay. So appearance does make a difference to you, is that correct? Okay. Anything else as you hear from witnesses? Okay. Juror number 11, what would you be thinking about?
Yeah, I was just thinking about taking all the circumstantial evidence and putting pieces together and how the person carries themselves.
Okay.
Kind of read people like that.
What about you, Juror number 10?
I'm not sure.
Gotcha. Juror number 5, anything you want to add?
See how their demeanor is, how the demeanor and what they're testifying to, how it all comes together.
Okay. We're talking about bias. We agree a bias can play a part in this. Juror number 8, do you have any, the fact that you know Ms. Hidalgo, is that going to play a part into bias into how you would view the facts of this case?
Well, I don't know her really well.
Okay.
Like I said, I believe that I can make a fair judgment. I just don't know that I want to live with the results of it, that's all.
Fair enough, but that, you would agree that's an example of a bias, is that correct? Could be a part of a bias, is that correct? One way or another.
Not sure.
What about, what would be some examples besides that of a bias you do?
I think when you have a bias that you already have your mind set about it.
Okay. Fair enough. Anyone else have anything to add on that? You'll hear from law enforcement witnesses throughout the course of this trial. They're like regular people, juror number 4. Would you agree with me? They're same as everyone else. They can tell the truth, they can lie, they can be treated the same as you would someone who's just a regular citizen, is that correct?
Yes.
Because they're people too, they can lie and be just as dishonest as a regular person, is that correct?
Yes.
What are your feelings towards law enforcement? Are they favorable or negative towards law enforcement?
Impartial.
Okay, impartial, okay. I think I know what that means, but I want to make sure you understand, what do you mean by impartial? You give them a fair shake or it just depends?
I really don't think about it.
Okay. Does anyone else have any biases or think highly or negative of law enforcement on the panel?
I don't think it's negative. I think we appreciate what they do.
Okay. Anyone else have anything to add on that? Okay. As Prosecutor Polder indicated, we'll hear from doctors and scientists that are experts in their field. Would that add credibility to their testimony, juror number 2, or would you view their testimony the same as you would a regular lay witness?
Testifying in their expertise, I would give them credit for it.
Okay. But you'd be able to view them as a person too, depending on, what they said in their field. You could synthesize it to see if that makes sense or not. Is that fair to say? Taking aside the fact they have an educational training there, they could have a wrong opinion, is that correct? On their field, is that right?
It's only the evidence, I trust their evidence.
Okay. You can treat them the same as you would anyone else? Okay. Anyone else on the panel would view a doctor or an expert differently than they would a regular witness?
I apologize. I have to go back one step as I'm thinking about it. I do realize that I have a bias in favor of law enforcement based on relationships and knowledge. I would give them more. I felt myself reacting. You said they would lie. I think I had a bias.
Okay. You said you got some family. Do you have family that are law enforcement?
Not close family, but I have relatives of relatives in law enforcement.
In this county or in other counties?
Other counties.
Okay.
So would you, when you hear an officer testify, you have a tendency to believe everything they say?
No.
You have a tendency to question everything they say?
Subject was bias, and I recognized that I would give them more credibility. I don't believe everything, but I would lean toward agreeing that they were.
So can you listen to what's said, and then if it fits in the case, give it the credibility it might deserve, but if it doesn't fit, discredit it?
Of course.
And you work it out with your fellow jurors?
Yes.
Thank you. You may proceed.
Thank you. Anything else with regards to expert, anyone else in the panel would like to share?
Anything else, what?
With regards to their ability to treat an expert differently than regular witness, they'd like to share with the court. We'll talk about another right that Mr. Montalvo has. Mr. Montalvo has the right to remain silent and not have that silent used against you, meaning you can choose to not get on the witness stand and testify. And if he does that, you can't use that silence against him. Juror number one, would you be able to do that if you chose not to testify in this case? Could you make no inference from that about his innocence or guilt? Yes, I am juror number one.
I'm fine with the silence.
Okay, what about you, juror number two?
Fine.
What about you, juror number three?
Yes, that's fine.
Okay, juror number four, would you be able to not use that against him? What about juror number five?
Yes.
Juror number six? Juror number seven? Juror number eight?
Yes.
Juror number nine?
Yes.
Juror number 10?
Yes.
Juror number 11?
Yes.
Juror number 12?
Yes.
Juror number 13? Juror number 14?
Yes.
And he also has the right to get up on that witness stand and testify. He's got the constitutional right to do that. And once he does that, he'd be treated as you could treat him as you would any other witness. You could judge his credibility, his ability to be biased, or any of the other things that you would judge any other lay witness. Would you be able to do that, members of the jury, if you were to get up on the stand?
Yes.
Yes.
Juror number two, you said you were on jury duty before, is that correct?
Correct.
You said here in this county, is that correct?
Yeah.
Okay. And without telling us the verdict, that you were able to reach a verdict, is that correct? Okay. Okay. I believe juror number nine, you said you're on a jury as well? in this
Correct.
county? And were you able to reach a verdict in that case?
Yes.
Okay. Juror number 12, you said you were on a misdemeanor case in this county, is that correct?
Yes.
Were you able to reach a verdict in that case?
No.
Okay. Juror number 14, is there anything else you would wish to share to help not only myself and Ms. Polder decide and Judge Aquilina your ability to sit on this panel?
Now that I think.
Okay. Juror number 7, you said you were a trained social worker, is that correct?
Yes.
Okay. And you said you deal with folks that have drug and alcohol addictions, is that correct? Okay. And you said you may have heard Ms. Gallegos' name, is that correct?
The name sounds vaguely familiar. I worked in like the hospital in a crisis setting. I saw hundreds of people.
Okay. Did you ever interact with her to your knowledge?
Not to my knowledge.
Okay. Okay. Anything else that I would need to know about your ability to sit on this panel? Okay. Juror number 1, is there anything else that we would need to know to assess your ability to sit on this panel?
Yeah, I have to say, my father was a police officer for
Okay.
30 years,
In this county or someplace else?
very good state of Michigan.
Okay. Would that give you any bias towards law enforcement one way or another?
I think that's favorite law enforcement.
Thanks for sharing. Juror number 2, is there anything else that you need to know to assess your ability to sit on this panel? Okay. Juror number 3, anything we need to know to sit?
No.
Okay. Juror number 4, anything else that we need to know?
No.
Okay. Juror number 5? Juror number 6?
I'm not hearing answers.
Juror number 5, is that a yes or a no?
No, nothing.
Okay. Juror number 6?
No.
Juror number 8? Anything else we need to know? Juror number 9, is there anything else we would need to know?
No.
Juror number 10? Anything else we would need to know?
No.
Juror number 11?
No.
Juror number 13?
No.
Judge, I think I'm good at this time for questions.
Thank you. On behalf of the people for cause,
None for cause, thank you.
on behalf of defendant for cause,
I don't believe any for cause, Your Honor.
on behalf of the people, and you may do multiples, peremptory.
Thank you. We would like to thank and excuse jurors number 1 and 7.
Thank you very much. We're going to call the jury hotline after 5. On behalf of defendant, anyone at this time?
the defense would like to thank juror number 2, juror number 4, juror number 8, and juror number 11.
Thank you. Remember to call the jury hotline after 5. All right, as to juror seat 1.
Juror seat number 1, sequence number 112.
What seat is that for number 1?
Number 1.
Sequence number
And then-
112.
For number 1?
Yes. As to juror seat 7.
Juror seat number 7 is sequence number 14.
As to juror seat 2.
Will be sequence number 253.
As to juror seat, I believe, are you?
I'm 14.
You're 14?
Yeah, where is this going? Sorry.
14 goes in juror seat 7, correct?
Yes.
Yes. You are in juror seat 2.
253.
As to juror seat 4.
Sequence number 185.
Let's see, I'm sorry.
4.
4.
As to juror seat 8.
Sequence number 31.
As to juror seat 11.
Sequence number 24.
Wait a minute, you were
Sure, I
juror
think we were
8.
seat 8. So that will be.
Yeah,
to-
I called them in the order that they gave me. So you're 8, sir, and she is 11. All right, so this part goes a lot quicker. And I think we need to take a break. The 2 who wanted to speak with us will hear you now. The rest, everybody will need to leave the courtroom and be back within 15 minutes, please. Steve, did you need to speak? Steve, sorry, I need to.
Oh, no, he was just.
Yeah, sorry.
So now. Yeah, come in. All right, thank you. You may all be seated. There are 2, do you mind if each other stays or would you like to be separate?
Mine, personally, Your Honor, I'd like to be separate.
Okay, ma'am, if you could just step out for a moment,
Between the doors.
Okay, just put it between the doors. Okay, ma'am, if you could please come up to the podium. And what is your number?
1.
And what is the issue?
Your Honor, I have a firm belief in the power of jury nullification. And I cannot promise, if sworn in as a juror, that I wouldn't feel a desire to use it after hearing the evidence. I can't just take the facts of the case.
So you can't follow the instructions and be fair and impartial, you can't make a decision?
No.
And is that a religious belief or?
I have a tendency to be rather biased. I've was listening to a lot of true crime and I've seen a lot of cases, and there's, despite the evidence, oftentimes I don't feel that the person or persons charged should be put in prison, because I don't think that evidence that maybe should have been considered that wasn't in the case. You know, that the fact that that wasn't allowed, I'm thinking, well, that should have been considered.
So you decide what the facts are, I decide what the law is, and the attorneys are both going to present evidence, even if the defendant doesn't have to. He doesn't have to do anything at all, so you don't have to call anybody. But his attorneys will cross-examine the witnesses. And the cross-examination process is really the greatest truth teller that we have. Can you listen to the evidence and use your common sense and then work out those issues with the jurors, or are you always going to be that person who says it's not enough evidence, I don't care what law enforcement did, it's not enough?
I don't think I could live with myself putting someone behind bars. I prefer that a guilty person go free rather than convict an innocent person. And I feel that if someone truly believes that they're not guilty, I don't know why they would bother with all of this if they didn't have a good reason to argue that point. I can't imagine putting someone behind bars for the rest of their life.
So no matter what, even if you had a video that this absolutely happened, you would still vote not guilty because you can't live with yourself. Is that a fair statement?
I couldn't say yes or no just based on a video. It's that was the entire trial, though.
I don't know what the evidence is. I'm just using that as an example.
Yes, if that was the only bit of evidence that there was just a video, there was nothing else. And it's like, this person is so obviously shown, it's clear that it has to be them, then I could say, okay, yeah, they're the ones that did it. But if there was other things, components in there, like maybe someone was set up, maybe someone was there beforehand, maybe a friend said, hey, can you go and do this for me, knowing that that person was going to be captured on video at that time, right? There would always be questions for me unless it was.
I understand. I appreciate your honesty. I know it's difficult for you to talk about because it's a tough thing to do. On behalf of the people, questions?
No questions. I think she's indicated that she is biased against the prosecution.
And on behalf of the defendant, questions?
I don't have any questions, right?
All right. Thank you very much for your honesty, and good to know you're watching television. It's not always factual, but yeah, your honesty is refreshing. So thank you, and just remember to call the jury hotline after 5. Okay.
Okay.
Thank you. You're released. Ma'am, thank you for putting you on the spot here. What is your jury number?
78.
And what would you like us to know?
I was petrified to even come here this morning. I'm on medication and have been for 20 years. That a lot of mornings a week, I can't get away from the bath.
That's okay.
And I'm petrified that that would happen if I was on a 2-week trial or even a week.
You know what, it's nothing to be embarrassed about. There's a lot of that going on. I can tell you my daughter's boyfriend actually has, which I did not know there was a thing, but he actually has a bathroom card so that he can go to the front of the line without anybody you know, medically, he has that. So a lot of people share that. We see that all the time. And so I appreciate your uncomfortableness and it would be disrupting if you suddenly had to go. So,
Right.
and we have actually had a situation with a gentleman who absolutely wanted to serve and he was wearing dependents. It became a problem. So we had to discharge him. So I appreciate your honesty. Please don't be uncomfortable about that. I bet you half the people in this room have that issue, so don't worry about it. But I appreciate you letting us know and I'm going to discharge you. If you want to, so you don't have to be in this situation, I just want to advise you that you can talk to the jury clerk and see what form she needs, but if your doctor would write you a medical,
Yeah,
then you can get out of coming at all and be sitting here. and
yeah,
worrying
I was
about it.
gonna do that, but I couldn't get an appointment within the time allotted to get that back in,
So if that happens next time, if you forget about it, you're doing it, and you get called again, because it seems like once you're in the hopper, you get in the hopper again and again. Just call the jury clerk, Gloria, and just reschedule it, and then reschedule it for a time after your doctor's appointment, okay?
Okay.
And so that's how you resolve that, but I appreciate, you letting me know, and it really is more common than you think, so no worries, you are discharged. Any objection we have, counsel?
No, thank you.
No, you're not.
Okay, have a good day.
Thank you.
Okay, let's take our 12 minutes or so and then we'll call it meeting back. We're gonna need that, that up there working too, I don't know, yeah, maybe not today, but for these kids. I don't know if any of those now, but do not, for the case, we'll need that. I feel like you have to, but I don't know, because our equipment has been, we finally got into the, and into the upward here on this side. Yeah. Okay, so now with this.